the jump, they literally, everybody who is on Megan's side feels like Tory is guilty because he's in jail. He is not in jail because he had gunpowder on his hands. He's in jail because he was a felon and that was his gun. It wasn't because he shot Meg, y'all.
And you just look at the evidence. Megan's testimony, medical records that confirm she had bullet fragments in her feet, the apologetic jail call from Tory, the neighbor who testified that they saw Tory fire the gun, the forensic evidence because the gun used in the shooting was found in Tory's vehicle. The DNA was inconclusive, but that was the evidence the jury used to convict him. So I just asked two simple questions. If you know they have all that evidence against you, if you're Tory Lanez, why wouldn't you just take the stand and simply say Kelsey shot her? And what reason would Megan have not to tell on Kelsey?
I agree with you 1,000%. But if this is a fact and this is true what this bodyguard is saying, I think it should be listened to see if it's proven or not, regardless, because it could open up some other things.
They said it was finished. 10 years, 3 felony convictions. The gavel slammed down in August 2023, and for a lot of people, that was the end of the Tory Lanez story. He was found guilty of shooting Megan Thee Stallion. He was taken away in handcuffs. Case closed, but now everything is being questioned again. New claims are surfacing. Medical records that allegedly weren't fully examined during trial are back in discussion. A man connected to one of the key witnesses is stepping forward with a version of events that flips the narrative on its head. Add in a brutal prison stabbing, a high-profile interview from behind bars, and a clemency push that reached the governor's office. And suddenly a case that looked sealed is back in headlines. Some say this is proof the system got it wrong. Others say it's a desperate attempt to rewrite history. And in the middle of all of it, one question refuses to go away. Was something missed? Because in court, evidence matters. But in the court of public opinion, momentum matters even more. And right now, momentum is shifting. To understand why people are reopening this case in 2026, we have to go back to the night everything started. It all goes back to July 12th, 2020. A pool party in the Hollywood Hills. Music, liquor, celebrity energy. By the time the night was winding down, 4 people were in a black SUV leaving the scene. Megan Thee Stallion, Tory Lanez, Megan's former friend Kelsey Harris, and their driver. What happened next became one of the most debated moments in modern hip-hop. According to trial testimony, an argument broke out inside the vehicle. Voices raised, accusations flying. The tension wasn't random. There were claims of jealousy, claims about relationships, claims about disrespect. The SUV stopped near a residential area. That's when shots rang out. Megan later testified that she stepped out of the vehicle and was walking away when Tory allegedly yelled, "Dance," before firing at her feet. She suffered gunshot wounds that required surgery to remove bullet fragments. Police initially responded to reports of gunfire and found Megan bleeding. Tory was arrested at the scene for possession of a firearm. But even in those first hours, the story wasn't clean. Early reports described Megan's injuries as cuts from broken glass. That narrative changed days later when she publicly stated she'd been shot. That shift created confusion immediately. Supporters said she was protecting everyone in the moment. Critics said the inconsistency raised questions. From that night forward, the case wasn't just legal, it was public. And the deeper investigators looked, the more complicated it became. Fast forward to December 2022. After 2 years of headlines, interviews, and internet debates, the criminal trial finally began in Los Angeles. Prosecutors charged Tory Lanez with 3 felonies: assault with a semi-automatic firearm, carrying a loaded unregistered firearm in a vehicle, and discharging a firearm with gross negligence. The state's argument was direct. They said Tory fired 5 shots from the front passenger seat of the SUV. They presented gunshot residue evidence found on his hands. They introduced ballistic analysis tying the recovered handgun to the shell casings at the scene. They leaned heavily on Megan's testimony, where she stated clearly that Tory was the one who pulled the trigger. Megan took the stand and did not waver. She described the argument. She described the moment she heard "dance." She described the pain in her feet and the fear she felt that night. For prosecutors, her consistency mattered. Then came Kelsey Harris. Back in 2020, she had reportedly given a recorded statement implicating Tory. But during the 2022 trial, she repeatedly invoked the Fifth Amendment. She claimed memory lapses. She avoided direct answers. That shift became one of the most controversial moments of the entire case. Still, the jury deliberated. On December 23, 2022, they returned a guilty verdict on all 3 counts. In August 2023, the judge sentenced Tory Lanez to 10 years in prison. For many observers, that was the final chapter. But for his legal team, it was only the beginning. Most cases fade after sentencing. This one didn't. Once the 10-year sentence was handed down in August 2023, Tory Lanez's legal team immediately shifted into appeal mode. Appeals aren't about retrying the case emotionally, they're about identifying legal errors, procedural mistakes, evidence that should have been handled differently. And that's where the phrase Brady violation entered the conversation. In late 2025, during a separate civil lawsuit filed by Meghan against a blogger, over 200 pages of medical records from Cedars-Sinai Medical Center surfaced in discovery. These documents dated back to July 2020 and included surgical notes about the removal of bullet fragments from Meghan's feet. Tory's team argued that the full scope of these records had not been properly disclosed before the criminal trial. They claimed that certain descriptions in early emergency room notes contained inconsistencies about wound trajectories. According to them, those details could have supported an alternate theory of who fired the shots. Under Brady v. Maryland, prosecutors are required to turn over evidence that could potentially help the defense. If material evidence is withheld, a conviction can be overturned. So, in December 2025, Tory's attorneys petitioned the California Supreme Court, arguing that these medical records represented suppressed exculpatory evidence. The Los Angeles County District Attorney's Office responded quickly. They stated that the records were not new, not exculpatory, and would not have changed the jury's verdict. They emphasized that forensic testing had already linked the firearm recovered at the scene to the shooting. Earlier appellate courts had already denied requests for a new evidentiary hearing, calling the additional records cumulative rather than transformative. Still, the petition remains under review. And while courts debated paperwork, something else happened that pushed this case back into the spotlight in a completely different way. Because the appeals weren't what really reignited the internet. A new voice did. Just when it felt like the legal fight was stuck in paperwork, a new name entered the chat: Bradley James. He wasn't a trial witness. He wasn't called by the prosecution or the defense. He didn't testify under oath in 2020, but in late 2025, he stepped forward claiming he had information that could flip the entire narrative. James said he had worked security around Kelsey Harris during the trial period. According to him, he overheard conversations where Kelsey allegedly admitted she had the gun and fired first. He claimed that Tory only grabbed her arm in an attempt to stop her, causing additional shots to go off. If true, that version paints a very different picture from what the jury heard. Supporters of Tory immediately pointed out something important. This account aligns closely with the testimony of Sean Kelly, the independent neighbor who said he saw two women fighting and gunfire coming from the passenger side of the vehicle. That overlap gave the story traction online. But here's the legal reality. A statement made in an interview or on social media is not evidence unless it's sworn, submitted properly, and allowed into court. As of now, Bradley James's claims have not been formally introduced into any appellate proceeding. No affidavit from Kelsey has backed up this version. No court has validated it. Still, perception matters, and for people who already believe the wrong person was convicted, this felt like confirmation. Because if Kelsey had access to the gun, and if she asked for immunity during the trial, then one question starts getting louder again. What was she protecting herself from? And that brings us to the most unpredictable figure in this entire case. If there's one person who keeps this case from feeling simple, it's Kelsey Harris. Back in August 2020, about a month after the shooting, Kelsey sat down with prosecutors for a recorded interview. In that statement, she reportedly placed the blame directly on Tory. She described the argument. She described the shots. Her account aligned with Meghan's version. At that point, the narrative looked solid. But when the trial started in December 2022, everything changed. Kelsey took the stand and became almost unrecognizable from the confident voice in that 2020 recording. She avoided eye contact. She hesitated. And when direct questions came, she invoked the Fifth Amendment over 50 times in less than 2 hours. When asked who fired the gun, she said she couldn't recall. When asked about details unrelated to incriminating herself, she still stayed guarded. Her attorney advised her to plead the Fifth to avoid potential perjury or self-incrimination charges. She had already admitted that she handled the firearm earlier that night. That alone placed her under legal risk. To some observers, that shift was understandable caution. To others, it was a red flag. Then in July 2025, Kelsey filed a sworn declaration in a civil case where she once again stated that Tory was the shooter, though in less detailed terms. She claimed fear and emotional trauma contributed to her reluctance during trial. So now her timeline looks like this: 2020, clear accusation; 2020, refusal to answer; 2025, reaffirmation with distance. That evolution fuels debate even today. Because when a key witness changes tone that dramatically, people don't forget it. And in a case built on credibility, consistency becomes everything. While the spotlight stayed on Megan, Tory, and Kelsey, there was one more person in that SUV that night who rarely gets discussed in depth. Jaquan Smith wasn't famous. He wasn't part of the inner circle. He was hired to drive for the night. That made him the only true outsider in the vehicle when everything exploded. And his testimony? It never changed. In his early morning police interview, just hours after the shooting, Smith described tension in the car. He said there had been arguing. He said alcohol was involved. He said he heard gunshots and saw Megan bleeding. But when it came to the biggest question, who pulled the trigger, he was clear about one thing: he didn't see it. He said he never turned around. He heard the shots, he saw the aftermath, but he couldn't identify the shooter. He didn't claim certainty where he didn't have it. That neutrality gave his account weight. During his 2022 deposition, his story remained consistent. No additions, no dramatic revisions, no emotional pivots. That consistency became important because in a case where one witness changed tone and another was directly involved in the conflict, the driver's steady account stood out. He also testified that Tory allegedly offered him money to stay quiet, an accusation the defense strongly disputed. Still, it added another layer to the prosecution's narrative. Here's what matters. The appellate court later described Smith's testimony as reliable circumstantial support for the verdict. But reliability isn't the same as confirmation. He supported parts of the timeline. He reinforced the chaos, but he couldn't answer the core question. And that unanswered question continues to echo through every new development that surfaces. Just when the legal fight seemed locked inside courtrooms, something happened that pulled this case back into the headlines in the most violent way possible. In May 2025, while serving his 10-year sentence at California Correctional Institution, Tory Lanez was stabbed multiple times by another inmate. The attack happened fast. Reports say it took less than a minute. He was struck repeatedly in the back, torso, and head area. According to statements released afterward, he suffered serious injuries, including damage to his lungs. He was rushed to an outside hospital and underwent surgery. The incident shocked even people who believed he deserved prison time. Because prison is the punishment. Being stabbed inside prison? That's something different. And the details raised uncomfortable questions. Internal documents later revealed that before his transfer, risk assessments had already flagged him as a high-profile inmate with elevated vulnerability due to media attention. Yet, he was still placed in general population. After the stabbing, he was moved to a more controlled housing unit with tighter monitoring and restricted movement. His legal team filed complaints arguing negligence. Supporters began circulating petitions demanding improved safety and renewed review of his case. But here's where the narrative shifted. For some, the stabbing became proof that he was being mistreated by the system. For others, it had nothing to do with the original conviction. Either way, it changed the public conversation. It wasn't just about a trial anymore. It was about survival. And that incident gave his supporters something powerful. A new emotional angle in a case that many thought had already reached its final chapter. But that wasn't the only move happening behind the scenes. After the stabbing, the energy around his case shifted from courtrooms to politics. In mid-2025, a group of public officials submitted a clemency recommendation to California's governor, asking for his sentence to be reconsidered. The letter argued that inconsistencies in witness testimony and newly surfaced medical documents raised reasonable doubt. It also highlighted his behavior in prison, including educational programs and rehabilitation efforts. On paper, it looked like momentum. Online petitions gathered thousands of signatures. Supporters rallied outside government buildings. Social media filled with hashtags calling for review. For a moment, it felt like something big might happen. But clemency isn't simple. In California, pardons and commutations are rare, especially in firearm-related cases. Most applications sit in backlog for months or even years. And politically, granting mercy in a case this high profile carries serious risk. At the same time, Meghan's legal team formally opposed any early release. They emphasized that a jury already reviewed the evidence and delivered a verdict. From their position, nothing had changed. That's the core tension. Supporters say new questions deserve fresh examination. Opponents say the system already worked as designed. And then there's the conspiracy layer. Claims that powerful industry figures influenced the outcome. Those theories spread quickly online, but none have been supported by court findings. Appellate courts have reviewed the record and upheld the conviction So, where does that leave them? The clemency file remains active but unresolved. No hearing date announced. No executive action taken. Public noise is loud. Legal movement is slow. And while politics swirls outside, the foundation of the conviction still stands inside the record. While social media debates new witnesses and political pressure, the conviction itself rests on something much less emotional: forensic evidence. And that's where things get complicated. At trial, prosecutors leaned heavily on gunshot residue testing. According to court testimony, residue particles were found on Tory's hands shortly after the incident. Under standard forensic guidelines, even a small number of characteristic particles can suggest recent discharge or proximity to a fired weapon. Meghan and Kelsey reportedly tested negative in official records. Supporters argue residue can transfer indirectly. Experts acknowledge that's possible. Being near a discharged weapon can sometimes produce similar results. But the prosecution's position was clear. The particle count met the threshold for recent discharge. Then there's the firearm itself. The pistol recovered from the vehicle was tested, and discharged casings matched its barrel pattern. DNA testing produced what was described in court as a mixed sample. It wasn't a clean, single-source match. It also didn't exclude him. The interpretation of that mixed DNA became one of the most debated parts of the trial. Trajectory analysis added another layer. Experts mapped the shots as coming from the front passenger area of the vehicle. Defense attorneys challenged the methodology. The court ruled it admissible. Appeals later reviewed all of this: chain of custody, testing protocols, lab procedures. Independent reviews examined the claims of mishandling. Appellate courts concluded that even if minor procedural gaps existed, none were strong enough to overturn the verdict. That's why, despite viral narratives, the conviction remains intact. Because in the legal world, speculation doesn't override documented evidence. And right now, the forensic backbone of the case hasn't cracked. Years have passed since that night in July 2020, but the impact still shapes both of their lives in completely different ways. On one side, Meghan continued moving forward publicly. She released new music, performed at major festivals, and stayed visible in fashion and brand partnerships. In interviews, she has maintained that she told the truth from the beginning and that the emotional toll of the case was heavier than people realized. From her position, the jury heard the evidence and reached a decision. For her, the matter is settled. On the other side, Tory remains incarcerated, serving a 10-year sentence handed down in 2023. Behind bars, he's reportedly continued recording music, releasing projects through his team, and speaking about resilience. In interviews and statements, he has consistently maintained his innocence. He has expressed regret for not testifying at trial, saying he believes it could have changed the outcome. Legally, the path ahead is narrow. Appeals are still being pursued, but appellate courts focus on legal errors, not retrying the facts. Clemency remains technically possible, yet historically rare in cases involving firearms. No executive action has been granted so far. Online, the debate hasn't slowed down. Supporters argue new testimony deserves a fresh look. Critics argue that relitigating the case publicly undermines a jury verdict. Others simply want the conversation to end. But here's the reality: the internet doesn't decide outcomes. Courts do. And unless a higher court finds a reversible error, the sentence stands. The speculation may grow louder, but inside the legal system, change moves slowly, and only when evidence meets strict standards. That's where this story sits right now. Unresolved emotionally, but resolved. After everything, the bodyguard statement, the shifting witness testimony, the prison attack, the clemency letters, the conspiracy, one fact remains unchanged. A jury convicted him. 12 people sat through weeks of testimony in late 2022. They heard Meghan's account. They heard Kelsey's prior recorded statement. They reviewed forensic reports, residue testing, and ballistics analysis. They debated credibility. And in the end, they returned 3 guilty verdicts. That verdict is what the legal system recognizes. Appeals don't retry cases. They examine whether legal mistakes occurred that were serious enough to impact the outcome. So far, appellate courts have reviewed the arguments about withheld evidence, witness handling, and forensic procedures. And they have upheld the conviction. That doesn't stop public debate. Supporters believe unanswered questions still exist. They point to inconsistencies and say the story doesn't fully add up. Critics argue that online speculation often ignores the actual court record. Meanwhile, conspiracy theories continue to circulate, even without verified proof. The clemency request remains pending. The appeals process continues, but neither guarantees relief. So, where does that leave this case? Legally, the sentence stands. Publicly, the conversation hasn't ended. 2 careers changed forever. 1 person rebuilding publicly. 1 person rebuilding behind bars. And a case that still sparks argument years later. Whether new evidence ever shifts the outcome will depend on courtrooms, not timelines. Until then, the verdict remains the final word. This ending will focus on the gap between what people believe online and what courts actually recognize. First, briefly remind viewers that viral statements, new interviews, and conspiracy theories don't automatically change a conviction. Then contrast that with how the legal system works. Appeals require proven legal errors, not public doubt. Next, highlight how social media can reshape narratives, but not verdicts. Emphasize that emotions, loyalty, and speculation live online, while rulings live in court documents. Close by posing one powerful question: when public opinion clashes with legal findings, which one truly decides someone